Good afternoon, everyone. As everyone starts pouring in here, just at 2 o'clock Eastern Standard Time, we'll get going here at 2:01. Just going to give everyone a bit of a chance to log in case you have technical difficulties. I do all the time, so don't feel bad. And then we'll jump right into it. So thanks for coming, making time today. I give it maybe 15 more seconds. 2:01 here. Still climbing up.
You could always do 2:02. I'll just talk faster. That's possible. That's possible.
Every minute counts. Every minute counts. Well, I'll just introduce the topic to start. First of all, my name's Brett. I'm with HR Covered. I run with recruiting and partnerships, and it is my great pleasure today to introduce Darcy Michaud, who is our VP of HR, and he's going to be talking about a subject that's very relevant, especially nowadays, post-COVID, managing leaves of absence and requesting medical. So there's going to be lots of good stuff in here. You don't want to miss it. Thanks for tuning in. And Darcy, I'm going to pass it over to you. We're almost at 2:02, and you can start your magic.
Awesome. Thanks for the introduction, Brett. He's being modest. He's a player. He's a VP of partnerships with HR Covered. So neither one of us are title guys. So that's why the modesty, but terrific guy to work with. And I'm glad he could join us today to help moderate the webinar. And welcome everyone. A lot of you I know that were attending, have attended the webinars before that I do. Usually my co-host, I have Brett today. Usually my co-host is my dog. But I've managed to find another place for him today, so he's not going to be barking in the background. But yeah, you can see it's Darcy and Brett that are here today to answer all your questions and hopefully provide some high-end knowledge on managing medical leaves, specifically around accommodations and medical documentation. So we're going to get right started because we always do. As you know, I talk fast. This will be recorded, so I know I talk fast. I apologize in advance. But we try to get through everything that we can. And then if you want, I think a copy of the recording will be sent out to everybody that attended, as well as our free offering, which is great. So you'll see at the top there, we do have a live Q&A at the end. So certainly most people ask questions about the topic that we're discussing that day, but feel free to ask any HR questions that you have. Just put them into the Q&A panel, question and answer panel, I forget what to call it. And at the end, Brett will make sure everybody's questions get answered. All right, so what we're discussing today, we're going to briefly discuss the different types of leaves. Not all of them. We're not going to do like the leaves of the employer improved leave of absences or anything like that. But the more important kinds of leaves that you're dealing with on a day-to-day or month-to-month basis. Medical leaves and accommodations. This is the part that I know a lot of you have reached out and have tuned in to hear. Medical documentation for every employer should ask. I know almost every single person here wants to hear about that. It's a super misunderstood and scary part of HR in so much as that there's a lot of private information and it's difficult for HR people and employers alike to know what they're entitled to, what they can ask for, what they absolutely can't ask for, and what will get them into some hot water. So certainly that's an important part of the conversation. And then non-cooperation and frustration of contract. In those rare times when things don't seem to go well through this process, there will be times and you know, when unfortunately you're going to have to end the employment relationship. It's never easy in a medical leave situation. It's always libelous. So we're going to discuss some ways in which it's appropriate and some of the things you're going to want to consider when you get to that point. So a few things to clarify right out of the gate, because you won't, it'll be difficult to absorb the information if you're not clear on these two things. So first off, when I say a protected leave of absence, because that's what we're really talking about here, we're talking about protected leaves of absences and non-protected leaves of absences. When I say a protected leave of absence, what I'm referring to is those leaves of absence that are covered by the ESA or ESC, depending on your jurisdiction. Essentially, what we're talking about is those leaves which employees are entitled to take. Sometimes there's documentation required, sometimes not, but they're entitled to take. They're typically non-paid leaves, almost all of them, and they have job protection. So that's what we mean by protected leaves. Non-protected leaves are basically any other leave that is taken by the employee that is not covered by the ESA and the ESC. They can be costly in certain circumstances, and we're going to get on that quite a bit, actually. So, and again, That's why these webinars are knowledge, because whenever we're talking about something that if you're not aware of or implement properly, it's going to potentially cost you a lot of money, fines, reputational damage, what have you. People want to tune in, and we're happy to provide that knowledge. So the first thing we're going to talk about is protected leaves. I'm not going to go, every province and jurisdiction has different protected leaves. For the most part, there's a lot of similarity. And what I mean by that, maternity leave, paternity leave, jurist leave, voting leave, all these different things. For the most part, from province to province, they're incredibly similar. There's a few oddities here and there, and in certain places, the oddity is really more about what benefit you're entitled to or how long you're entitled to it for. But for the most part, all protected leaves are essentially the same across jurisdictions. The things that you have to remember about protected leaves, and I've already kind of touched on this, is what protection means is you get job security. You continue to accrue seniority while you're on a job protected leave. You continue to receive benefits while you're on a job protected leave, and they can be short-term and long-term. Okay, so I know I have a lot of folks here that are US based and have Canadian fiduciaries. It forms a big clientele for HR Cover, being we're a valued service organization. But it's important to understand that in Canada, we don't have, if your benefit carrier might have a difference between, or a definition between what a short-term disability leave and what a long-term disability leave, but our jurisdiction, our ESA or ESC, they don't define it. If you're on a leave that lasts 2 weeks, you're on a sick leave. If you're on a leave that lasts 17 weeks, you're on a sick leave. That's what it is. Okay. And the other thing that's super important to touch on, and this is a webinar unto itself because it's super confusing, Canadian and American employers alike, protected leaves and employment insurance are two different things. They're not associated with one another at all. A lot of people think that, oh, paternity leave and maternity leave, you get EI. That's true, but they're two separate processes, two different governing bodies. You can be eligible for a protected leave in any jurisdiction in Canada, but not eligible for EI, and vice versa. You could actually get EI in certain cases where it's not actually a protected leave. So this is important to differentiate the two. Again, I'm mentioning that as a characteristic of protected leaves. We're not going to go into that in great detail. This is more of a macro slide, if you will. The process is simple. This is confusing again for a lot of my employers. When an employee wants to go on a protected leave, the process is simple. They tell you why they're going on a protected leave. They provide verification if needed. Then they go on the leave. That's it. If you have internal paperwork that you want to have them fill out, that's up to you. But as far as what is legislatively required, that's it. The only thing the employer is required to do is issue the record of employment so they're eligible to apply for EI. Question I get often, even if they don't apply for EI, if they're without insurable earnings for 7 days or more, you must issue the ROI. It's a $2,000 fine every single time. And this will be it's become a point of emphasis for Service Canada coming out of COVID, because a lot of people did not do ROEs properly during COVID, and it's caused a lot of disruption. Trust me, the government causes their own disruption all by themselves good enough. They don't want help from us. So it's super important that you issue the ROE whenever someone has an interruption in earnings. In most cases, the employee does not require you to give you the date of the leave or when they're going to come back. So it's super, like when someone is going to take a leave of absence that is, associated with a child death, for example, or an illness of somebody in their family, like a family medical leave or something. That's not something that people typically can anticipate. No different than with a maternity leave. Typically, you get that date when they plan to take the maternity leave, but babies don't always come whenever they think you're going to come. So, a lot of times the actual date is not, all the legislation asks you, and basically the Ontario legislation makes me laugh. It says you must provide this date, but if you don't do that, provide that date by this time, the employer still has to grant it to you. So it's basically just a guideline. The more and super important thing is that employees don't have to give you a date when they're coming back. So this is frustrating. I get it. For employers that are trying to schedule, like especially when it's a maternity leave or a paternity leave, you are legally not able to require someone to provide you a return date on their leave of absence for maternity and paternity leave. Okay. If they don't want to provide you with a date, they don't have to. The only thing you need to know is whether they're going to take the full year, or if they're for the purpose, and they have to do this for EI, so they'll be able to tell you this, is whether they're going to be planning to take the year or the year and a half. Okay, that's because you could do that with EI. So if they tell you off the jump that they're going to take a year, but they're not going to give you a date, you have to assume that the date that they're coming back is the end of that year. If they tell you it's going to be 18 months, then you assume that the date they're coming back is 18 months. On the other hand, they can come back early. So this is where temporary employment contracts for coverages are super important, that you have a clause, that there's this thing out there where people are saying that you don't have to have termination clauses in temporary contracts. You will get yourself in a whole bunch of legal trouble, short and aside from this, what we're discussing today. But for what we're discussing today, it's super important that you have a termination clause in your contract that allows for a week or two of notice to have to be provided by the employee. So if you have somebody coming off for them and they say, hey, I want to come back, then you have something. Now, the legislation itself requires the employee to provide you with 4 weeks written notice that they want to change their date, going backwards or forward. Okay. So you're going to get that notice from the employee that they want to come back 4 weeks in advance. But if your termination contract or your term employment agreement does not have a proper termination clause, which allows you to, end that employment contract, then you might be on the hook for the entire duration of that employment agreement. And that could be months, tens of thousands of dollars. And the employer, what I said earlier about the employee can actually request to extend a medical or extend a protected leave. That is absolutely the case, again, with the 4 weeks written notice. However, they're only allowed to do that until the point where the ESA maximum or ESC maximum allows. So if the ESA maximum for a specific leave is 28 weeks and they want to extend past 28 weeks, you can grant him that extension if you like. It would no longer be a protected leave, but it would be an approved leave of absence by the employer, but you're under no legal obligation to provide it. Same thing with bereavement. This is the one that in Ontario, for example, people are entitled to 2 days bereavement leave. That's all you're entitled. If someone asks for a week to go off on bereavement, you do not have to grant it. Most employers aren't that harsh, but there are a few that, rely on their employees pretty heavily. So a differentiator. So this is what I kind of touched on in the first slide when we're talking about medical leaves, okay? Or protected leaves versus non-protected leaves. Non-protected leaves, the number one non-protected leave is for medical reasons, right? So that could be a leave for illness, disability, LE, what have you. There's lots of reasons why you would go on a medical leave. There is no protections afforded to you by the ESA or the ESC. So that's why we refer to it as non-protected. That does not mean, as I suggested earlier in the first slide, that it's not costly potentially. Even though it's not covered as a protected leave under one of the acts or codes, it is one of the protected status under the Human Rights Code, disability. So even if someone goes off for a week, right, which you would think, oh, they're off for a week, they're just sick. Technically, the potential that could turn into a disability makes it a disability under the Human Rights Code. So as soon as someone goes off sick for any length of time, they're covered under the Human Rights Code and they are afforded certain protections that way. It's not so easy to access for the employee and it's more difficult to understand for the employer. The one thing you do need to understand is that when you violate a protected leave under the ESA or the ESC, very easy for the employee to take access or take recourse against you, and the penalties are relatively menial. When someone takes action against you because you violated their human rights, yes, it's a more difficult process for the employee, but the repercussions could be severe. Just showing up at a human rights tribunal, win or lose, will cost you $10,000. And there's no, if they make a false claim, you will get your money back. So it's super important that you're aware of what your obligations are, what your rights are, and what the employee's obligations and rights are too under, when it pertains to non-protected leaves. So again, I'm going at a quick pace. We have a lot of stuff. We're already 15 minutes in. So non-protected leaves. So again, medical leaves are the most common. So I've already belabored this. I've said it twice. It's important, but basically we're not going to do it again. Managing sick leaves, it requires, so for all you employers out there that don't have an HR department or an HR person, or for those HR people that don't have a lot of experience managing sick leave, you have to be careful about the landscape that we're working in nowadays. And COVID has a lot to do with this. It's not that it didn't exist prior, but it definitely has a lot to do with it. And I'll break it down into two categories. There's people that need sick leave and there's people that manipulate it. And that's as simple as that. And during COVID, there was a lot of people that figured out, especially with the gratuitous way the government had to, pay out, CERB and all that kind of stuff. There's a lot of people who figured out how to manipulate sick leave. What you're finding now is, and this isn't even an issue of me doing this for 27 years and being a little bit jaded, what you're finding now is people are manipulating the accommodation process. And they're asking to work from home. People that have been called back into the office are coming up with medical reasons why they shouldn't, and they're asking to work from home. That's why the medical is so super important, because if you don't ask for the right medical, you might as well just set up their home office, right? So employers just say, well, we don't have any. It's not that easy. It's not that simple. The medical dictates the play. To a certain extent, you have a lot of play there, but you can't start without the medical. So we'll get there. The first thing you need to know, and this is where the next three, for the people that are my clients that I know are on this call, or some of my team is on this call as well. There's certain things I get frustrated about. I'm a super nice guy, but I do get frustrated. So these are the couple of things that really get me frustrated, and it's going to be in these next 3-4 points. The first thing, never allow your employee to self-diagnose. I don't care if you trust them. I think that's great. I think that's great for culture. I think that's awesome that you have a trusting, all that kind of stuff. Never allow your employee to self-diagnose. If they tell you they have a disability, if they tell you they have a sickness, if they say they're going to be off for 4 weeks because of this, you get medical, right? You never, like the biggest diagnosis nowadays, especially when around, cognitive and mental well-being, and the focus that's been placed on that, is around someone coming in and saying, I suffer from depression, or I suffer from anxiety, or I don't do well under pressure, and I've been told it's a medical condition. You can't take that at face. You have to get, there's a lot of different reasons, which we're going to discuss, why you need to get medical, but it's super important. You should never be taking an employee's word for something on a medical issue. You should be getting medical verification to actually, one, substantiate it, but for reasons we're going to talk about, two, know what to do next. Okay, you are entitled to appropriate and satisfactory medical. Those words are in parentheses for a reason. That's actually terminology used in case law for what you're entitled to as an employer. Okay, so I have a 13-year-old boy who just graduated yesterday from grade school, and I'm quite certain if I gave him a piece of paper and said, write a note that says off work for medical reasons for 1 week, he could probably do it. You're entitled to more than that. And if that's what you're accepting as an employer, when someone comes in and says, this person needs 2 months off work for medical reasons, and you walk away from that and think that's okay and that's acceptable for that employee to provide that, and you're not entitled to more, you're wrong. Okay. So, and hey, this is the great time to find out, right? You don't want to be finding out when, after this employee being on medical for 3 months, and then you go see an employment lawyer, HR expert, and they say, did you get appropriate medical? Well, no. And I go, well, you can't do anything now, right? You're kind of hooked. You needed to ask for that medical at that time. So just so everyone's clear, and anyone who's familiar with workers' comp or WSIB in Ontario, an FAF, a functional abilities form, is a very common used tool. It should be a clue that these multi-billion-dollar insurance companies use these tools as what they need for medical. So that should be a clue to how important an FAF is for you. You can do the same thing for non-occupational work-related injuries or illnesses. So every time you get someone that tells you that they need to be off work, actually, I think that's the next slide, so I'll put it up. Every time someone needs to tell you they need to be off work for any length of time, that they have a disability or a condition, or even if they're not going off work, but they divulge to you that they suffer from depression, you need to go get that FAF done so you can get what you're entitled to. What you're entitled to, capabilities, restrictions, and most important, a prognosis. Super important. If you don't know, if you don't get an estimation, if you don't get an estimate from when that doctor or medical treating medical practitioner says they're going to be back, then you can't manage a claim properly. You need to be working on a timeline so you can work with that employee to do return to work, to do accommodation, to have realistic expectations from an operational perspective too, right? It's just not about that. There's other obligations that all companies have besides trying to get their workers back to work when they're ill or sick. So it's super important. The FAF does that for you. So if you're a client of mine, you've already heard this. Anytime an employee tells you they're going to be off work for a week or are off work for a week, you send the FAF. It's automatic. It should be as automatic as you getting in the car and putting your seatbelt on. It should be part of your process. Okay. So that's super important. I drill that home with my clients and with my team. I will drill it home today. And there's a reason for it. Like when we get through this, you will see why it's so important. But an accommodation, really quickly, just an overview. As you can see, an accommodation can be anything. It could be physical changes to the location. It could be working from home. It could be part-time hours. A very underutilized accommodation, which is effective for a lot of reasons, is when an employee is unable to attend work regularly, which happens all the time, and they say it's for medical reasons. Say to that employee, you know what? We will accommodate you by providing you part-time hours. If you have a history and the medical to support that, it's not constructive dismissal. It's actually an obligation under the Human Rights Code and a right that you have. say that you will support them by offering them part-time hours. Going back to that prior slide where we talked about the two different types of workers, there's a type of worker that needs this, that needs help, that needs support. A worker that needs help and support, they will appreciate you saying, you know what, I appreciate you being flexible with your hours and your work schedule, so I can, deal with my, my condition of whatever sort it is, and still be able to make an income and be part of this company. The employee who's trying to manipulate the system, who will now be making 50% of their pay, all of a sudden you're going to see whatever it is that ails them go away pretty quick. It's a very effective, underutilized type of accommodation. But you could see the most common accommodations that we've come to know over our years, I'm sure, is things around physical altercations, right? Or even like an ergo setup is an accommodation. But more and more, you're starting to see the flexible hours, the working from home. And that's why I know a lot of you are here. I'm watching this Q&A blow up, and I'm just hoping it has nothing to do with anything like my voice, or like if I'm going too fast, or if everyone can hear me. But we're going to need like an hour for Q&A. Anyways, the employer has the right to accommodate and offer return. So the actual idea that, because I have some employers, and I get it. Don't get me wrong. I know the difference between claims management and disability management, and there is a difference. Another slide, another presentation for another day. But there are some employers out there that will not ask for appropriate medical because they don't want to be on the hook to accommodate their employees. And again, I get it. Claims management being what it is. The problem is it's a two-edged sword. You have a legal obligation to accommodate. Even when the employee doesn't ask for it, you have a legal obligation to inquire. It's called a duty to inquire. So, and it's important that you do that for different reasons, but it's a two-edged sword, because obviously there's going to be times when you ask for medical, and that's going to force your hand on, your ability, your obligation to accommodate. But there's also going to be times when you want to get somebody back to work. And if you didn't ask, and having that obligation to have return to work or accommodation actually suits you, because it's proven. Like my first 3 years in HR, I worked at the board, WSIB, and the stats, they don't change. If you're off work for a week, the percentage, if you're off work for 3 weeks, the percentage of you coming back to work within the next 2 months drops 20%. If you're off work for 8 consecutive weeks, the percentage of you coming back to work within another 8 weeks is less than 50%. The longer people stay out of the workforce for various reasons, one of which is stigma. Quite frankly, it's again underseen, but the reasons people stay out of the workforce, and there's the longer you stay off, the more difficult it is to get them back. And part of that is because employers don't ask for right medical. Right? So you can make reasonable inquiries. You're going to get people that say, this is my personal information. You're not allowed to ask that. Yes, you are. You're in the course of an employment relationship. It's a contract. If someone doesn't come to work, you have right to question why they're not there. If they tell you why they're not there, you have right to ask reasonable questions about that and require proof about that. Just always remember, for a lot of different reasons, but for the purpose of this webinar, the employment arrangement is in fact a legally binding contract that goes both ways. When they're not holding up their end of the bargain, even if it's for a reason that's justified, you have the right to, seek out validation as a justification. And the two-edged sword I was talking about, why it's important when that person that comes to me, because we do get this, we understand what, HR is. HR is a grudge buy to a certain extent. We do have some clients that are incredibly proactive and you want to do right by their employees and they reach out to us and say, can you set up the HR department for us? Sure. We have other clients that will come to us because they've had an unfortunate, ongoing or experience with an employee or a situation, and that's fine too. But this is one of those things where someone has come to us after the fact. This is an example where someone who was off work for a year, and they provided semi-regular notes, like every 2 months, they said, we just need a doctor's note, and the doctor's note need to be off for another 2 months for medical reasons. Sat off work for a year, still paying benefits in the whole bit. They tried to fire, they tried to intervene after a year, seek all the appropriate medical, and say, okay, now we're going to manage this claim. Now we're going to manage you back to work because we just don't want you out there because we're paying all these benefits, and our lawyer or our employment expert said we have to continue to pay these benefits. This company, and it's a big company, went out and tried to manage this person back to work. The employee didn't cooperate. They terminated the employee. The Human Rights Tribunal said, you know what? You had a reasonable an obligation to make reasonable inquiries, a duty to inquire. Because you let that employee sit there for a year and then you just decided to intervene and try to manage them back to work, you can't terminate them. They will sit there and their doctor or medical practitioner who you trusted for the last year will be the one managing this claim, and they will tell you when they're ready to come back. So that costs them tens of thousands of dollars, but that's why it's important. The time to get appropriate medical is out of the gate. Okay, so I'm going to zip through this slide quick because for anybody who's done return to work or accommodation, it's pretty straightforward. This is just the accommodation process. Okay, so accommodation, and this is super important. The only thing you need to take out of this slide is it's a cooperative process. Both parties have to be part and parcel of the solution. If one side isn't cooperating, that's the grounds for termination or non-accommodation, which we'll get to at the very end of the slide. But basically, both parties sit together and they work together to come up with something. The employee has every right to say what their preferences are. And a lot of times nowadays, their preference is to work from home. Sure. But if that's either not doable, it's not affordable, and you can find an alternative measure, even though it's not the employee's preference, to provide an accommodation, that's what you want to do. We see this with the AODA all the time, the accessibility legislation in Ontario, where someone says, because employers have to provide accessible information to clients that come in, and a client comes in, they're blind, they would like to have a document, they would like to have it in Braille. No, that costs too much money. How about this? We'll have somebody here come and sit you in a private room away from all the other clients, and we will read that document to you. That is a completely acceptable accommodation. Definitely not what the customer wanted, but it serves the purpose, so you're allowed to do it. You don't always have to go to what the client or employee says. The employer will review the accommodation. Essentially, you will measure up what the accommodation itself, what accommodated duties or accommodation is available, return to work, and if it suits within your expectations around undue hardship, which we're going to touch on, then you have to provide it. If it doesn't, either you don't have the accommodation to be offered, and again, then they would go on a medical leave, which is the sort of accommodation. So you don't have that accommodation that needs to be offered, or it meets the bar of undue hardship, which we'll touch on in a second. Then you can deny the accommodation request, and it would behoove you to sit down with that employee and talk about why you're denying it, and then discuss with your employment expert or your employment lawyer what the next best steps are, whether termination or frustration or any of those different things are an option, or whether simply putting that person on a medical leave to return when they have the majority of their bona fide occupational capabilities back, so you can provide accommodation. Undue hardship. Sorry, okay, we're 28 minutes in and we're not getting there. So we might have to pick this webinar into two. It matters not the size or scope of the employer. So this is the greatest misnomer about undue hardship. If you're a small, there's a little bit of truth to it, but for different reasons. If you're a small employer, you're not bound to undue hardship. That's not the case. It has nothing to do with the size of the employer. What it does have to do with is about your means. So at the end of the day, the first two things are about cost. The third thing, which is where you'll see the most cases for undue hardship, is health and safety. The first two things are, if the cost of the accommodation that would be so great that it would have a significant impact, negative impact on your corporation. We're talking about, when I say negative impact, I mean you having to lay somebody else off or fire somebody, you having to be non-profitable for 3 months, the period of the accommodation. Those types of things, that's a significant impact. That's where size does matter, but it's not the size, it's the money relative to the size. For companies like Walmart, or companies like, bigger companies like benefit companies or anything of that nature, undue hardship doesn't exist for these first 2 points. There is nothing, even if you had to pay $100,000 to accommodate somebody, there is nothing that's going to justify the $2 billion you make versus that $100,000 you have to accommodate. The Human Rights Tribunal or a court isn't going to look at it. So in reality, for bigger, well-to-do businesses, undue hardship on the first 2 points doesn't exist. For smaller to medium-sized businesses, you still have to make the case. So it's easier to make the case because your revenue and profit won't be as great. So having a costly accommodation could significantly cut into that. Even when you have found that, the next thing you have to do is investigate external funding. So the government and many non-for-profit programs does have funding for people with disabilities or requirement accommodations. So it's not just good enough to say this will cost me $100,000. We can't do it. You have to go and see if there's a funding source out there that will pay some of that $100,000 and then remeasure. And you have to show proof of this, by the way, if you ever get called on it by human rights. And the final one is if the accommodation poses a health and safety risk. this is actually not uncommon. So, and it usually happens in blue collar industry. So for example, let's say you are a construction worker and the only accommodation that can be made is on site, right? So you have to wear steel toe boots, and the nature of your accommodation is you broke your foot or you broke your leg and you have a full leg cast. That person can't go on site because they can't wear the steel toe boots or the caps. Hence, it's a health and safety risk, hence undue hardship, and the accommodation doesn't have to be made. In that case, the accommodation would be medical leave until they're able to get that cast off and be able to wear appropriate PPE for the job site. Medical disclosure when requesting accommodation. I know it's a lot. Again, they're going to get the slide of all of this, and I'll try to zip through some of this, and we might even bring this back as a webinar and break out the latter half of it. But we'll keep pressing through here. Medical disclosure when requesting accommodation. So this is important that throughout the course, a claim, and again, this goes for claim management and disability management. A claim takes on, it has a timeline, it has a life of its own. In the earliest stages, the only thing you're entitled to is capabilities, restrictions, and prognosis. There might be other small things, but that's what you're really entitled to. As the claim takes on more years, you could start to ask more specific questions about treatment and the type of, and all these different things that will allow you to operationally plan and get a better grip about what this is going to look like long-term. Okay, so request for a permanent, there's a difference between a temporary accommodation and a permanent accommodation. A temporary accommodation does require you to accommodate, but the standard for where, or the bar for which you have to accommodate is far less. Okay, you don't have to create work. You don't have to replace somebody. Do you know what I mean? Stuff like that. With a permanent accommodation, the standard is way higher. You may be in a position where you have to find work. You may be in a position where you have to create a job. The difference is that the benefit for the employer, what the employer is allowed to do, the flexibility you have is way greater, because you don't have to look with a temporary accommodation, because they're going to be coming back to their regular job. You can't change their rate of pay. You basically, essentially, you really can't change meaningfully what work they do. There's some moderation to it, but with a permanent accommodation, everything's on. You could change your rate of pay, you could change your position, you could change your position from full-time to part-time. It's what you have. You have the duty to accommodate, but what you can provide accommodation for is a big difference. And again, a whole nother webinar. IMEs are a popular topic of discussion of late. I've had a lot of clients asking if they can use them, and well, some what they are, and then asking if they can use them. So an IME is an independent medical exam. This is something where you have reason not, well, typically if there's conflicting medical advice, so when an employee goes doctor shopping, or you're looking for a second opinion, or there's reason not to believe there's a whole bunch of reasons you would acquire an IME, but an IME is you, the employer, having to pay $4,000 to $6,000 on average, and sometimes it's more, to have a doctor who's independent provide you with the medical information you need. The employee is not bound unless you have something in your employment contract right out of the gate, but the employee is not bound to submit to an IME. Here's the problem for the employee. The number one reason an employer will ask for an IME is because of non-cooperation. The employee refuses to give the doctor or give the employer, not the medical necessarily, but the medical they're entitled to. They're giving you that one note that says off work for 6 months, and they refuse to give you something more. You turn around and ask for an IME. The worker's not required to say, the worker can say, I'm not doing that. I'm not doing an IME. If you combine the two things, the non-cooperation of the employer or the employee to provide adequate, appropriate, and satisfactory medical, and the refusal to provide an employer-approved IME, those two things give cause in many cases for the justification, which will lead to termination. So that's super important. And then, of course, all records required. This is something that I guarantee you, and I want to be wrong. Doing this for a while, it's what I see it all the time. If you have your medical information, your functional abilities forms, doctor's notes, et cetera, et cetera, et cetera, inside the employee file with all the other employee records, that's against privacy legislation. Medical information must be kept in its own separate file with only 1 or 2 people in the entire organization that have access to the medical information itself. There's medical information that could be passed down on a need-to-know basis, and it doesn't need to be everything in an FAF. It might be just enough for that operational manager, that HR person, to be able to make an accommodation, but you don't hand somebody the FAF and say, here you go. You just don't do that. And it has to be kept separate in a personnel file. So that's something, again, that people need to be aware of. We're probably going to go about 2:50, so we have about 15 minutes left, so we might make it. Medical disclosure when requesting accommodation. Employers have the right to access information to fulfill their duties up until undue hardship. So, and you will get it if you haven't got it already. You will get it where employees say this is personal information, you're not entitled to it. We've already talked about that. Employment arrangement, contract, you are entitled to it. Details of any functional limitation experience that the employees blah, blah, blah. This is what you're entitled to, information nature. Details of how the treatment or medication. Now, again, this is one of those things that as you go longer in a long-term leave, that this is the stretch, right? So treatment and medication. So on a typical FAF, on the FAF I've developed anyways, I will put on there, has this person been referred to a specialist? And if I get, and I specifically did that for cognitive injuries, because quite frankly, and if there's any medical doctors on here, I apologize in advance, but treating family physicians are not necessarily qualified in all aspects of cognitive illness, right? There's specialists for everything, no difference than when you go to an auto mechanic, they're not going to do the paint job. When you go to an HR person like myself, when it gets to the point where it's clearly crossing the realm of employment law, I'm passing it off to our HRC lawyers. Right? There's always specialists in everything. We just have to know our place. As a claim of disability or medical absence goes on, you have more right to what I have there in the purple. Those things about because you have at a certain point when someone's been off work for 6 to 8 months and you have no explanation, adequate information for why they're off, you could start asking, are you getting treatment? What kind of treatment are you getting? Is it affecting you in any aspect that has nothing to do with work so we can get you back to work? So these things are super important. In cases of total disability, I can't see that with the screen going up, I'm sorry. In cases in timing for return, at least indicate, okay, this goes back to the prognosis piece that I was speaking to. It's super important. You can't manage a claim without a prognosis. So typically what you're looking for with medical information is you'll get that prognosis and it'll say, sometimes it don't say when they're going to be back, but it'll say next checkup in 2 weeks' time. So that should be automatic from your claims management. Whenever any of you are doing disability management, if you're doing disability management and you get a doctor's note said that this person will be reevaluated in 2 weeks' time, one, you're telling the employee that you expect to hear from them in 2 weeks with the form that you're going to give them filled out and returned. You waiting till that 2 weeks, because this happens all the time. The employee goes to the doctor 2 weeks later, comes back and says, yeah, I need another 2 weeks off. Well, can I get, well, I was just there. Can I get medical? Well, I was just there. And then the medical they give you is not what you want, right? So disability management is a management function. It's not an employee function. Employees do have some duty to cooperate 100%, but management has to run the train. They're driving the truck here, right? So when you get a note saying we'll be reevaluated in 4 weeks, make sure that employee is firmly aware that in 4 weeks' time, you expect them to be reporting back to you. And here's the form that we want you to have them fill out in 4 weeks' time, and we will not accept anything else. Okay, so that's super important. An employee is not entitled, and this is the one thing you got to know, this is the one thing you can't ask. And if you do ask it at any point, or for some of my clients who right out of the gate, provide, and I work with a couple of benefit companies and what have you, and they've shown me medical that their clients request, and it's like 3 pages long, right? It's got it basically asks you what color your colon is. It's ridiculous. And at the end of the day, they're saying, well, we're not asking for a diagnosis. If the tribunal deems that a series of questions gives any reasonable person an adequate determination of what the prognosis is, you can ask it. So you have to understand out of the gate, a simple functional abilities form, which gives you all the information you need, right? It really does. A simple functional abilities form is all you need. You really can't start diving in until the claim starts to take its own life, the life course of its own, right? You have to be careful with yes, you need more detail, but it has to be appropriate and satisfactory. Appropriate also means appropriate for what you're entitled to. So managing longer term leaves, a lot about what we're talking about already. So typically in Canada, for our US employers, again, LTD, there's nothing in the legislation which dictates what a long-term disability leave starts, but typically what we go by is what benefit companies have dictated, and also when our EI system, employment insurance, ends. And that's at the 15 to 17 mark, depending on the policy or the circumstance. So typically once you're past that mark, you can say that you're managing a longer term leave. Again, screen getting covered up by the picture. If you have a benefit provider, and this goes back to the point I made in the last slide, if you have a benefit provider, they're going to provide it, they're going to manage that claim for you, but they're not, at the end of the day, they manage the claim for the purpose of entitlement. They don't manage the claim for the purpose of employer obligations, or what's the word I'm looking for? Purview. So when you have a benefit company that's working with you on a return to work plan, and they say, we believe this person's 100% ready to go, and you get them back to work, or you look at what they can do, can't do, and you're like, no, this isn't happening. You can say to the benefit company, no, this isn't happening. This person is not 100% ready to go. We will work with you and give them, a part-time accommodation, and then you can continue to pay benefits for the other part-time. Most benefit companies and benefit brokers are great that way, but every once in a while you will get, I don't want to say overzealous, you're just going to get, you're just going to get a benefit, a caseworker or an adjudicator, what have you, who doesn't necessarily understand your business relative to the restrictions and capabilities, and tries to push this person back to work, which in a lot of cases isn't appropriate. Managing long-term absences can also be libelous. So when you think about what we talked about the amount of information you're able to ask for, and then the extent for which you are required to accommodate or not accommodate, the longer the claim goes, the more rights and obligations you have, but that also comes with liability. So, there's a reason why these boutique firms that only do claims management and disability management exist and charge an arm and a leg. They really do. It's a minefield. There's a lot of potential liability there. You have to be cognizant of it. And, selfish pitch for HR Covered, we have disability management. We have disability management skills and skill set right here. So, and we're not anywhere near as expensive as the boutique firms out there. So just something to keep in mind. And this is an often asked question. I get this all the time. When someone's on a long-term disability, especially my American clients, because it's quite, when you're an American business and you're starting up in Canada, our rules are a little bit more stringent in certain cases anyways, but it is a kind of a hit to the head when someone's been off work for 2 years and you're still paying benefits, and you say, oh, can we just stop the benefits? They go, no. Well, how long do we have to pay them for it? Well, indefinitely. And I go, you need to, that's why the construction of your employment agreement is super important. There are ways with appropriate notice, and in cases where someone's off for a year or two, and then you say, okay, they're in the midst of a claim, this is when they need their benefits most, we're going to cancel their benefits. You're going to have to give a year or two notice of you being able to cancel those bonuses, or you're going to either get sued for constructive dismissal, or you're going to take the task with human rights. So, those are things that you need to be aware of. And again, same thing with terminations as benefits. Most cases, you cannot terminate somebody when they're on a sick leave or a disability leave. There's a few cases that we're going to discuss, but there are cases where you can build it into your employment contract. The wording for that should be lawyer made. I've seen a lot of wording that after 2 years, if you're off work for any reason, that we can terminate you. After 2 consecutive years that we can terminate you, that's implying a frustration of contract. Right. So whether or not that's legal or enforceable is entirely based on the wording. But those are the kind of cases, that case right there, even though I have a lot of experience in that personally, that's the kind of case, that type of draft wording, that's the kind of case that, again, specialists do what they do. I'm kicking to our lawyers at HRC Law, because that's somewhere, that's a clause that you do not want to mess up on. Okay, we're on the last 2 slides and we've got 7 minutes. That's not bad. And that's taking it to 10 minutes before the hour, folks. So we can run the Q&A a little bit later if anybody has questions and they're willing and wanting to stay. So job abandonment. So this is an incredibly misunderstood terminology, or term, if you will. Job abandonment is not what people, oh, they missed 3 days of work without calling in, we're going to terminate them. No, doesn't work that way. The job abandonment process implies the manager, the employer doing what they're required to do, which is to reach out to the employee, just like progressive discipline. The job abandonment process is almost identical and to the progressive discipline process. And when I say job abandonment, folks, what I mean by that is this is something you would use. It's the title you might use. There's other titles you can use. I prefer job abandonment for people who are non-cooperative in this process. So basically, when someone is refusing to provide you medical, but stays off leave, or refusing to provide you appropriate medical, but stays off leave, I define that employee on an unauthorized leave of absence. The employee can scream and yell to the top of their lungs that are on a medical leave. If I don't get the adequate proof that you need to be on that medical leave, then you're on an unapproved leave of absence, which means I need you back to work. I either need the medical or I need you back to work. This is the job abandonment process. The process, you send the employee a registered letter. If you could get it by email and you have proof, so be it. I always say registered letter or courier. But in fact, the only reason you're doing that is because for them to get that letter, they need to sign off that they received it. And that's essential for a job abandonment process to get just cause. Okay. If you have a read receipt on your email, so if you send someone an email saying you need to come back to work by this date, or you may enter the job abandonment process, which is the first step, and they do a read receipt, you're fine. But assuming you don't have that, then it should be going out to by registered letter or courier, so you can get that signature saying, if you don't get us the medical we require by 5 days from now, 5 business days from now, you may be considered to be going through the job abandonment process. So what happens 5 days later? You don't get the medical or the appropriate medical. You send out the second registered letter and says, if we don't get this medical or you return to work by this date, you will be terminated for job abandonment. No different than the progressive discipline process, making the employee aware of what the consequences are, and then the next step of the consequences, and then following through on it is what is required in progressive discipline, as well as the job abandonment process. Deadline to contact, and again, that was inherited what I just said about the process. Maybe I just skipped through all this stuff by accident. I get ahead of myself, ask anyone on my team. So I basically went through the entire process there without putting it up. So now this is the key point. Whenever you terminate somebody for frustration of contract, job abandonment, anything to do with human rights, especially when it's about them not participating in a process, or them not, in this case, I guess it's the same thing, them not participating in the process and or providing appropriate medical in this case, you should always be putting in the bottom of the termination letter at the end, you were terminated with cause for job abandonment. Should you be able to provide basically, should you be able to participate in this process and provide what we asked for you after this date, even though we've terminated you, we may consider the status of your employment. Okay, it's super important, because if they do come back to you after the fact, there could be a trillion different reasons why someone doesn't, participate in a process or get you the appropriate medical. Maybe they're insistent on seeing their family doctor, and their family doctor, you don't have to abide by that, but maybe they have a specific reason that they don't want to divulge to you, and they only want to see their family doctor. They get to the family doctor a week after you terminate them. They bring in the note, and in fact, they have a disability. You want to give yourself that out. You want to give yourself that line that says we may consider. So then you can go and talk to your employment expert, your HR expert, or your employment lawyer and say, okay, this is what happened. What do we do? It gives you a reprieve. It gets you a get out of jail free card. You can stick by the termination by all means. And at the very least, you're disciplining them, right? You're absolutely disciplining them. The fact that they didn't follow the process and you had to jump through all these hoops by itself is disciplinary worthy. So if you give them their job back, that's one thing, but you're going to discipline them after they get the job back. Okay. So last slide, and then we're on to questions. Frustration of contract, again, super misunderstood term. Frustration of contract is not as simple as this person can't do the job any longer, or can't do the job I want them to do, so we're going to fire them. Frustration of contract is basically what it is. It's when the contract, and remember I said earlier, employment agreement contract, the contract is essentially frustrated. In order for something to be frustrated, one person can't live up to the obligations that they set out in their part of the contract. However, if there's a possibility that they may be able to do that down the road, then you can't terminate them. You need to reach this bar of frustration of contract. And frustration of contract means there is no reasonable likelihood that the employee can, or very unreasonable, employee return to work within a reasonable time due to their disability. So medical professionals don't necessarily get trained on this. They really should be, because the odd medical professional will make a mistake, but typically most of them are pretty cognizant they might get trained on this. I know they do stuff on W7 workers' comp, so maybe this is part of it. But when a doctor writes, prognosis, unlikely to return to work, that's part of your basis for frustration of contract right there, because the medical doctor is telling you that this person is unlikely to return to work. So you have the basis, not by itself, but you have the basis to move on from that, saying, well, this employee can no longer satisfy their end of the employment agreement, therefore it's frustrated, so we're doing a non-disciplinary termination. Okay, I know that sounds weird, a non-disciplinary termination. All it means is you're severing the employment agreement. It's not disciplinary. It's done, right? So one person didn't follow through, we're just ending it. So, if a doctor wrote like this, we'll be off for at least 6 months and we'll reassess at that time. And you say, well, 6 months. I can't go 6 months. I'm going to have to fire this person to get in the position. You're going to get taken to court and you're going to lose, or you're going to get taken to human rights and you're going to lose, right? Frustration of contract in Canada, I know for our US employers, this is frustrating. Frustration of contract needs to show that the employee's capability to return is going to be way, way far out, if at all. One, two, that what they're going to be coming back to, if they can come back, in no way resembles the bona fide occupational requirements of the job. And the hardest criteria for you to get, if there's no likelihood that the employee can maintain a regular schedule. That's way more difficult, because a lot of times you should be able to accommodate, but depending on the nature of the job, there's times when you won't be able to say, if an employee says, I can return to work, but I can only come back for 2 hours a day, or I can always come back, or I can only come back for 1 day a week. The nature of your job might not allow that, even if it was an accommodation. So in cases like that, you might be able to reach the bar of frustration. It's super important. Frustration of contract is not a, even as a experienced HR pro, is not, if it ever came down to the decision of making a determination of frustration of contract, that's not something that I'm not talking to our HRC lawyers about. This is something that is firmly in the realm. And for all you HR people out there that ever think that this is within your realm, there's a lot of complexity around this issue. And it's super important, especially for the senior HR professionals on this call. That includes everybody on my team that I know is here. When you get into this realm, you always have to understand as professionals where your expertise and purview stops and where somebody else's begins. This is that one of those points. So it's a super liable. We can help you with the process getting there, and we can explain it to you, and we can, help you build a case for it and make sure everything that you did up until that point was correct and right. At the end of the day, when it comes decision time, that's when you're going to want to speak to one of our lawyers. I will do this. So beyond quick, it's 251, compliance, health and safety, employee lifecycle consultant. We have Brett is the VP of our recruitment team. Amazing. Our results are off the chart. Like, honestly, we've been running recruitment for about a year now, and our results are off the chart. We get A players and we do it at a high grade. We have our own legal department. It's the only unlimited legal advice product in Canada that I'm aware of. You pay a monthly fee or annual fee. You can go to them and ask many questions of an employment lawyer you want. It's awesome. Consulting, anything you need, pretty much, not always, but anything to do HR, health and safety for the most part that you need, we can do, even if it falls out of our membership, which we're making changes to coming. So keep an eye on that, because it's amazing. But even if it falls out of our membership, it falls into our consulting bucket. We have consulting people on our team, including myself, with 20, 25 years of experience. We can help your company. Doesn't matter what it is. All right. And thanks for giving me the minute there to indulge me. Questions? Hopefully, I'll just say this before, hopefully everyone found some value in there somewhere. I'm going to have a drink of water before I pass out.
Nice work, Darcy. That was great. And I think we set a record for Q&A. I think we need another hour. But I was trying to go through it and just to kind of prioritize it, or if people ask multiple questions, just to try and make it a bit fair. But I'll jump into it right now. So one question that came up is, what happens if, and I'm assuming they mean if the person's on long-term disability and you see that they're on Instagram and they're posting photos and they're having fun at a party. Is there anything you can do about that?
I will give you this parallel example, and I'll give you the ruling on it, just so you can appreciate what I'm going to say. Employee was on disability. Employer found them on Facebook or wherever it was, in Bermuda or somewhere tropical, having a vacation, and the employer went to terminate them. The arbitrator is a union environment. The arbitrator turned around and said that them being on vacation and taking a mental break has no bearing on the capabilities or restrictions that prevent them from being at work. There
you go. Okay, so
I know it's frustrating.
Okay, here's one. Is it acceptable to ask for a second opinion on the status of employees' health? So let's say they're on injured, they're off and they're injured, they're on long-term disability. Can you at any point, as the employer, ask for a second opinion from a different doctor?
There really needs to be a reason for it. So again, the longer you go into a claim, the more stake you have for an IME. So like, let's say, for example, the treating medical practitioner is treating, this is the thing of the day, so I'll keep on coming back to it, a cognitive illness. They've been off for a year. This person has, every time the doctor writes back, has this person been referred to someone else? The answer keeps on coming back, no, right? At a certain point, there has to be an expectation that, you know, you've been off for a year, there's no improvement in this person's state of health, that they're not coming back to work. An IME might be appropriate at that point to say we're entitled at this point to, you know, more advanced or more detailed information, which might be a second opinion. Right? Disability companies and benefit companies, because it's a condition of enrolling in their benefits, are able to do that. Employers, it's much more of a challenge, and it's on a case-by-case basis. So there is occasion where that can happen, but it's definitely something you would want to be talking to your HR expert or employment lawyer about.
Okay, how about am I required to offer work from home, even if that's something that we're not set up for as a business?
It depends. Because what you're set up for a business and what you're capable of as a business are two different things. And that's an important thing that I say to all of my employers. It's like, it's something they don't want to hear, and I don't blame them because I don't want to tell you. But if what you need to get done can technically be done at home, and the medical restrictions suggest that this person can do their job, but only at home. And I'm going to tell you right now, folks, there's very few times where that's the case. And if you get the right medical, you'll be pushing back a lot. But if they can only, for whatever reason, the medical justifies the fact they can only do that work at home, it doesn't matter if your place of business isn't set up for that. If you're capable of making that happen, then you have to, depending on again, different factors. Permanent accommodation, temporary accommodation, depending on all the factors in the case, specifically relative to the requirement for accommodation, relative to the capabilities and restrictions dictated by the medical, relative to your capabilities as an employer. It's a lot of relatives.
Okay, so what type of documentation is appropriate to request if someone is off for mental illness / stress? Like, is an FAF still applicable or not?
Yes, it is. And I am happy just saying now, we do a lot of things. We do a lot of, custom reach outs, or I forget what we call it when we do a giveaway or, something at the end of a webinar. When I believe you will be reached out at some point to say thank you for participating. And if you want an FAF at that point, ask the person that reaches out to you and we'll get you one.
So what happens if to try to accommodate, you move the person's schedule from full-time to part-time and the employee does not accept it? Can you terminate them?
If they have an obligation to participate in an accommodation, if it's reasonable. So if you have a medical basis for putting somebody from full-time to part-time, and that's reasonable, and you can point back to like a big example of this, and this is, I'm using a touchy one, but it's common. This is not an easy accommodation, is when someone has migraines, right? A lot of times there's specific factors that dictate what migraines to play personal, something that they have on Sunday nights that stresses out the employee, which causes them to miss a lot of work on Mondays, et cetera, et cetera. So if you can go back like 2 months and say, listen, traditionally you've only been able to make it into work 3 days a week, and most Mondays you're missing, and then you have medical saying that they have this migraine and they need to be, accommodated for their migraine, then yeah, that's a reasonable accommodation. And if they don't participate in that accommodation, you go through like what it would be the job abandonment process. No, we're not, this current employment arrangement is not working out. We're providing you this accommodation. You have until this point to, kind of get into it. And after you go through that process, if you have to terminate, you have to terminate. You're going to have a fight at the end of it. But again, it's just like anything when you terminate for cause. If you've, dotted your I's and crossed your T's, you always have a good chance of winning.
What happens if a doctor says there's no timeline for a medical condition?
Then you ask,
and no expectation that it will be resolved anytime soon.
Then you ask for the next time that they're going to be seeing them, which you're entitled to. And if the employee comes back and says, my doctor won't give me that either, then I said, you need to go see another doctor. This is super important. It's 160 people still on the call for Q&A, which is great. That's awesome. If you remember, there's one rule after this webinar, and sorry again if there's any treating medical practitioners on here. I don't work for the doctor doesn't work for me, and the employee doesn't work for the doctor. The employee works for me, not the doctor. If that employee, if I'm entitled to something from my employee who works for me and I have a contract with, and their doctor, who I have no control over, does not provide them with the medical information that I am entitled to, go see a different doctor. That's on the employee. The employee's how the employee gets this information. I know it sounds harsh and cruel. Most doctors are great. Most doctors want to help their employees get back to work. If they don't want to give the appropriate information to help their employees get back to work, that suggests a red flag to me. Could be a character flaw, but let's go with the red flag. So, but yeah, no, that's pretty much what you would do. But that's an important rule about how, like, the doctors in vital. Like, I'm not dismissing the doctors' process in this. And if they if they give you everything they need, and then at the end of the day, they give you everything they need, and an accommodation is what's required, then an accommodation is what's required. But you're entitled to what you're entitled to.
You can grab a sip of water. This one's a couple sentences, and I was trying to do the real quick ones. We are a fully remote organization. As we operate with remote employees and have a diverse workforce from various countries, we are particularly interested in understanding how we can process leaves to accommodate the needs of remote workers and employees from different cultural backgrounds. How can we address this unique challenge and consideration faced by these employees, ensuring equitable access to leave benefits and support regardless of their geographic location or cultural context?
Okay, so that's a half-hour discussion. but I'm gonna sum this up, because the person who asked the question might not be aware, and maybe they are, and it could be taken in that context as well, that when you hire employees from a different location, the location where they live, not the location where your company is located, is the jurisdiction for which their employment legislation presides. So if someone asks you for a maternity leave and they live on the other side of the world, unless the maternity leave that you're going to offer them, which is from Canada, is a better benefit than what they're providing over there, then you're entitled to provide them what they're providing over there. So that's why this is a loaded question, and I could never answer this question without at least knowing that much. Are you going on a best practice principle, or are you trying to adhere everybody from all these different places to your own process, which is Canada centric? It's like I said, I mentioned a few times, I have a lot of American based clients, and this is a struggle for them, right? It's a struggle that they have a system that they have in the United States and that works there with the requirements they have there, but then they have their Canadian fiduciary and they like to keep it the same, but they can't. So it's either you respect each jurisdiction's, leaves and how that works, and you have to do it separately, or you find a culmination of all of them and you do best practice, which is a lot of work and can be very costly when you look at the best practice from 15 different locations and say, we're going to give that to all of our employees.
Okay. Okay, so what happens if, and you've touched on this, but I'll just go over it again. If an employee says he's going on medical leave, has a doctor's note, but no indication of what the issue is, but the insurer wants to know, how do you get that information to pass it on to the insurer?
The insurer is not entitled to, in most part, until it gets there. First off, if the insurer wants to know, they should ask themselves. And you should be in agreement with the insurer to allow that to happen. They technically have unless there's some type of agreement where the employee is divulging information, or the employee is divulging information to the employer to divulge to the insurer, unless there's a confidentiality agreement in there's a breach. So if the insurer wants something, they should be going directly to the employee to get it. Because you're not entitled to something you're not entitled to. The insurer might be entitled to more, because if they're going to approve a certain type of drug, for example, they might need to know what the drug is being prescribed for. So that would lead to a diagnosis. You're not entitled to that. So you can't be expected, your insurer, and I can't believe this is happening, but your insurer cannot expect you to ask information of the employee to pass on to them that you're not necessarily entitled for. So either there's not a confidentiality agreement or process in place, and that's just wonky, or you need to go back to your insurer and explain to them, yeah, we're not doing that.
So would the insurer then communicate with the doctor directly in that case, if it was for some sort of specific medication?
If they have some type of appropriate relation or arrangement with the employees entered into via contracts. So when you sign, I don't know if most people might not be aware of this, but when you sign your enrollment forms with a benefit company, when you first sign up with a company, or the company signs up with the benefit form, there's a lot of legalese in that contract. I guarantee you, amongst those legalese is what the employer is entitled to, and how the insurer is entitled to, and how they should go to get it. So if in that legalese we're talking about, if they have the authority to go directly to the doctor, then they can do that. But this is a process that if this is a denial or not thing, this is a process that they should be handling if they need information that you're not entitled to. And that's only if they're legally allowed by contract.
So someone starts a job, they've been working for 2 months, they're in the probation period. They have a claim for WSIB. Can you terminate them because of that?
No.
We should do just yes and no answers. We'd be
Yeah, we can
through the
write
Q&A in no time.
Yeah, no, it doesn't, like, when a disability is a disability, they could start working on the second day, and this does happen. And again, people that actually need it and people that do this for a living, people will start work within a week, they're injured, and then they're off for the next six months. You can't, anytime you terminate somebody, I can speak firmly from Ontario, not necessarily for every board across Ontario, but anytime you terminate somebody within 6 months of them coming off of a claim, the WSIB will automatically open an investigation. And unless you can show that the reason for you terminating them had implicitly nothing to do with the fact that they were injured, you will get fined by WSIB, or worse off, taken to the Human Rights Tribunal by that employee.
Okay, here's another long one. I'll read. You can take a sip of water, take a deep breath. We have an employee that was off due to an injury who came back after a couple of months. Unfortunately, they are still too hurt to do full time and provided a doctor's note requiring part-time work for 3 months. We let them know that their salary would be impacted by the accommodation. And 2 weeks later, they provided a new doctor's note stating that they will be completely off work for 3 additional months. Any advice for how we can support this employee? And number 2, ensure that what we are doing is legal.
No, that's fair. That's actually, it's a really good question, because that's indicative of a very common thing. And again, I'm not sure which medical you're getting. The only thing I'm hearing out of that question, I know it's not to go back and forth, but the only
mental health. Sorry, yeah, it's a mental health thing.
Right. So, okay, perfect. So the only thing I'm getting out of that, and mental health makes it a little bit more tricky, but the only thing I'm getting out of that is you got this medical note saying they need to be accommodated at part-time, or they need to be off for 3 months. What I'm not hearing is, did you get the restrictions and the capabilities? So I'll give you a perfect example of why this matters. And this is why the FAF is a must-have tool. I have a client. We're going to win. We're going to win, but we're in a legal position right now with their lawyer who's out to lunch. Sorry, just an opinion. They submitted a FAF because at the direction of I provided this client direction to give them an FAF. They wanted to work from home for a cognitive injury, like a mental health issue. The doctor wrote must work from home for 3 months for a mental health issue. And then where it said capabilities and restrictions, marked off 0 capabilities, 100% on everything. Restrictions, nothing. All the way along the line, I said, you don't have to accommodate that person. Well, the doctor said they have to be off for 3 months. I go, I don't care what the doctor said. The doctor also said that they have no restrictions and 100% capabilities. That's what you're entitled to. That's what you make the decision on. The suggestion of the doctor, you should never discount that. But at the end of the day, it's the restrictions and the capabilities and the prognosis for different reasons that dictate your pace of accommodation or your play for accommodation. In this case, you should be reaching out. If you want to help this employee, like honestly, reach out with the FAF. You can I even encourage clients, or employees, clients as it may be, to even write a little note to the doctor to explain it so they can get, like, if you're really trying to help the employee, so they can understand what you're trying to do. So we have a duty to accommodate. We want to accommodate this person. We need to understand what they can and can't do to see if we're able to provide them with accommodation or not. So, get them to check off the capabilities and the restrictions. It may very well be that you may be able to continue to provide this person full-time work with just, other kind of altercations to their job or modifications to their job that, because it's within their capabilities and restrictions. So that's why it's super important, right? A doctor's suggestion about, basically their direction or suggested direction is only valid if it has the basis for making it. And that's the capabilities and the restrictions.
So someone's been working reduced hours for a couple months, 20 hours a week, but they need them at 40 hours a week, the employer. What can the employer do to get that person back at 40 hours a week, or because they need the job to be 40 hours a week, essentially? Is there anything that they can ask for in terms of a note?
Well, yeah, this goes to the difference between disability management, and then we're getting into claims management, which is a little bit different thing. And again, we're going to do a separate webinar on that because I've said it like 4 times and I haven't explained it. And I don't want to. It's not the easiest thing to explain. But what ends up happening at a certain point, you can manage a disability claim. At a certain point, you have to manage the claim itself. And what I mean by that is you can, when you have a temporary accommodation, you are required to accommodate for as long as you can. You're not required to create work. You're not required to hire somebody else to do that work for them. If it's a full-time job and you were able to accommodate for this long, then at a certain point, you're going to say, we no longer have that accommodation available. We no longer can do that. So until you're able to come back to work on a grad, and this is the other thing, because it sounds like it's something that's missing. For anybody who hasn't heard it or hasn't had a lot of familiarity with return to work is fine, but it doesn't work in most cases unless it's graduated return to work. So what graduated return to work is, especially when you know you're going to have a longer case, which this one is, you should be sitting down with the employee, having the employee work with their medical practitioner to say, let's work on a plan to get you back to work full time. Just not, hey, you can work 20 hours a week for the next 2 months, and then you get the doctors that work 20 hours a week for the next 2 months. Let's work on a plan. In 8 weeks time from now, we want you working 26 hours a week. In 10 weeks time, we want you working 30 hours a week. Get the doctor's buy-in. A lot of times the doctor doesn't know that that's what you're trying to do, and they will work with you through the employee. You can always ask the employee with permission to speak to the doctor, but they have to give it. But a graduated return to work, if they're resistant to the graduated return to work, or it's not possible for medical reasons, then at a certain point, the accommodation is the medical leave, right? I put that in my slide because a lot of people, like, they didn't understand when people were off on COVID, they're like, how do we accommodate this? We don't have work from home, we can't do it, the whole bit. And I go, medical leave. Well, isn't that failing our duty to accommodate? No, when it reaches a certain level, on that spectrum, the accommodation is the medical leave. You're not punishing them. It's non-disciplinary. You're simply placing them on a leave of absence and holding their job for them until they're able to come back and do at least most of the bona fide occupational requirements of their job.
What happens if, it's a shift environment and someone has say there's multiple shifts, and the doctor says, my patient can only work, the 8 to 4 shift or 10 to 6 shift and not, the evening shift. Are you bound by that?
Not unless there's some capabilities or restrictions that suggest that I get that all the time. Dude, like, that is a very common question from my blue collar clients. I have one client who I think gets a request once a week. Do you know what I mean? So it's a bigger fabricating company, and they get it at least once a week. People wanting to get off the night shift and onto the day shift, and they come in with a medical note saying they must work the day shift. And I go, send them an FAF. We get the FAF back. There's like little stupid things checked off on. I go, there's nothing there that suggests, there's nothing about those capabilities or restrictions that would cause that person to have to work the day shift and not able to work the night shift at all. Yeah. Typically, it's a very common thing, but you just, again, going to sum it up, go back to restrictions and capabilities. That's what you base your decision on, not what the doctor says all by itself.
Someone comes to work with a doctor's note saying that my patient does much better when they work for 3 days and then they have 5 days off, as an example. And then I'll reevaluate this in 3 months. Is there anything that the employer can do?
Yeah, look, I will say this. When a doctor writes a note like that, I'm prone to sit down and talk to the employee and try to work it through with them and do a graduated return work plan, because that's a doctor who's keenly aware, if he or she worded it particularly that way, that's a doctor that is good at their job. They're keenly aware that cognitive illnesses, mental wellness affects people different ways. And because they said they do better, that to me illustrates someone that the doctor wants to work with the employee should want to work with us. If they don't want to work with you, that's fine. Then you go back to what I said earlier about the restrictions and capabilities. Show me something that dictates that this person shouldn't be working for full-time, period. Show it to me. Like, show me some restrictions. And you got to keep in mind, a good FAF, the one I drafted, it has 2 boxes on it. One's for physical injuries, and the doctor, it says, fill out if it's a physical injury, fill out if it's a cognitive illness. So they fill out anxiety. Are they able to work with others? Are they able to respectfully communicate with others? Things of that nature. Can they concentrate on their tasks? Those are the kinds of things that you're trying to measure. When it comes to full-time or part-time, very rarely, or night shift to day shift, very rarely is there anything about a medical condition. And it does happen, don't get me wrong, I'm not dismissing it outright, but is there anything about a medical condition that suggests that needs to be accommodated?
Someone had asked earlier, what an IME is.
Sorry, I said it quickly in the slideshow, and I apologize for that, for not putting it up.
Oh.
It's an independent medical exam. And my apologies, you get used to using these abbreviations when you use them often. So an independent medical exam is something you would request in certain rare circumstances of an employee when you're looking to get, sometimes it's a second opinion, but most of the time it's to get adequate medical.
Okay, and this is being recorded. Everyone will get a link emailed in about 2 days, just so that's a question that people have had. Okay, someone's been on LTD for 5 years, maybe more, and then they decide they're coming back. Does the employer have a requirement to find them a job?
Well, yeah, if you never terminated them. So like, yeah, like the first thing you're going to want to do is you're going to get started, and it's not the same type of thing, but typically in a case like that, I would send the job description to the employee and a specific note to give to their medical practitioner saying, please read this job description. Can you tell me if this person is 100% capable without accommodation of doing this job? You know, or you don't have to put it without accommodation thing that can get you in a little bit of hot water, I suppose. But is this person 100% capable of doing all the regular duties of their job? That medical note doesn't always come. Quite often in reasons because the doctor doesn't, or the treating medical practitioner does not want to put themselves in libelous way. So yeah, but if they're still with you and you haven't terminated the employment arrangement, technically they're still employed.
And just, I'm just curious, how would you actually terminate someone who was on long-term disability for multiple years?
Right. So that goes back to what we were talking about earlier about either having a clause in the contract or seeing frustration in contract, or having something where you provided them with more than adequate working notice. It's no different. You can terminate people as long as you don't violate their human rights or, you know, ESA, which we're talking about here, but you can terminate people with adequate notice, right? So you could technically, even though I don't advise it, you could technically terminate somebody that's been with you for a year and is off for 3-4 weeks. So they're technically covered by the Human Rights Code by giving them an egregious amount of notice, because if they took you to court, that's what they're going to win. If they take you to human rights, it's different. The notice, it's a different ballpark, right? But technically, you just, it's unwise to terminate somebody that's on a medical leave unless you can show frustration or non-cooperation. Now, in that case, for somebody that was off for 5 years, at some point, like 5 years for me, and this is in my experience because I've had to terminate a few people for frustration. If I knew if someone was off that long, at some point I would have initiated or at least tried to go down the path of frustration of contract. At 5 years out, they would have already been terminated because there would have been something along the way that likely would have said that this is either happening or it's not going to happen anytime soon. And not happening anytime soon is not acceptable for frustration of contract out of the gate. But after they've been gone for 2 years and a doctor says it's not going to happen anytime soon, you might have a pretty strong case.
Can an employer request an FAF form from the employee directly?
So sorry, Brad, I missed something.
Yeah, I don't think that makes sense. Can an employer request an FAF form from the employee directly?
Well, you would provide it to them. The employee
provide it.
Yeah, an employee doesn't necessarily know what an FAF form is, nor should they. They definitely shouldn't have access to it readily. Although I've been in some operations when I actually was in the field HR where I've provided FAFs, like for when I was a director at a municipal government. So my firefighters, my paramedics, some of my nurses, I would make sure they had an FAF in their pouch. So if they did get hurt wherever they were, it was already with them and it was going to them at the hospital.
How often can an employer ask for an update when someone's on a leave?
Depends on the nature of the leave and the length. So the longer the leave, usually the longer durations between you asking for leaves. It's not unreasonable out of the gate to ask for updates every few weeks. Once you get into, and this is really the doctor's fault. If the doctor catches on and says this person will be reevaluated in 4 weeks' time, it's reasonable to ask in 4 weeks' time. You don't undercut the doctor that way, right? The doctor is giving you information that you need to manage the claim. So if the doctor says we'll be reevaluated in 4 weeks and you got the appropriate medical, so you have everything you need, that's where you're cooperating with the doctor because they provided you with that adequate, required information. So you wouldn't undercut them. But if they just say off work for medical reasons, then I'm every 2 weeks until I get better information. And then I would go every 8 weeks. And every 8 weeks is a reasonable amount of time for longer term claims.
And just in terms of like chain of communication, is it better for the employer to use email just so it's there showing that, you know, effort has been made, or is phone fine?
It's it's actually a good question because it's super practical. In those kinds of cases, especially if I'm worried at all that this claim might not be on the up and up, in other words, there might be ulterior motives for this person being off, aka you do a performance appraisal, it's not great, the next day you get a medical note. Everything I do is through email. I want it all written out.
People want to know for your FAF form, is that something that you share with clients, or is that something you know, like only use in certain circumstances?
I share it with clients, and as I said, anyone on this call who, you know, participated, we will extend one to you for free. But I don't insist, it's not my purview. I really encourage all of my clients to use this as part, like, as much as you, when someone starts, you would give them an employment agreement. When someone goes off work for 5 days, tells you they're going to be sick for 5 days or more, or tells you they have a disability, give them the FAF. It should be that automatic. If you have a policy on this, it should be written in that at being aware at 5 days, or at 5 days, or when disclosing a disability, you will be required to fill out an FAF. It is that important of a document to claims management and disability management.
And is there any cost for the employer when filling out or dealing with FAF forms, and does that falls on the employer, I take it, not the employee?
Not necessarily. This has always been a sticky point. I wish the governments would actually, you know, do that. There's certain things that frustrate me, obviously, being engaged in these committees that do make employment legislation. I've vented on this before. Make a call. Is it the employer's obligation or the employee's obligation? The way it's written right now is it's the employee's obligation to provide you the verification and medical that you're required to as an employer. It says nothing about whose cost it is, but because they're the ones who are required to provide it to you upon reasonable ask, then they're required to pay for it. Where it becomes an issue is when you have those employers that require a sick note for every leave, or a sick note every if you miss 2 consecutive days. I'm at the point, folks, and just as an opinion, and you don't have to follow it, but I'm at the point nowadays, we know the flu takes 4 to 5 days to get better. We know that in COVID, it took 5 to 10 days to get better. And even at that, you're still in danger of bringing an employee in who cross-contaminates. You should expect when an employee tells you they have the flu, that they're probably going to be off for 4 to 5 days. The requirement to get a doctor's note after 3 consecutive days is not something I necessarily support. Only because we ask a lot from our medical community when we ask them to fill out these FAFs, right? It goes both ways. So, you know, I'm more of a fan of a requirement to fill out, after 5 days, not 5 business days, 5 days. So, you know what I mean? So that I'm more of a fan of that. But in those cases, if you were asking for it every day, the ministry might take issue with you because it's an unreasonable, or even human rights, because it's an unreasonable request for medical. Alternatively, the employee technically is on the hook. Sorry for the long answer for the short question.
No problem. And employees are not required to disclose any disability, be it physical or mental, prior to starting a job.
No, and not during certain job, not during the job either, unless it's required in a case like this, right?
Okay.
So if they get into a situation like this, they're going to have to they don't necessarily have to disclose a disability if they can tell you what they need to tell you without actually disclosing it. But yeah, and I know that's frustrating, but if you look at the bigger social economic picture, there's a reason for that, because there's too many employers that systematically and historically, as soon as someone told you that they had a disability, would throw your resume out the window. And being an all-inclusive, you know, or an inclusive society, we just can't say to somebody that has a disability that you can't do this job. It's not right.
Under what act or code is the employer legally obligated to accommodate? Is that a human rights?
Yep.
Okay, that was a question. Okay, we're getting there. Okay, let me see. Sometimes they're not always questioned. Is a unionized in a unionized work environment, can we offer part-time hours for full-time employees? I'm assuming that that's because you're accommodating them.
Yeah, it depends on your collective agreement. But if it's not, if this process isn't spoken to directly in a collective agreement, that makes it a management right. So for all you unionized employers out there, because I was a chief bargaining agent for 12 years, so I could say this, with passion. If you could keep something out of your collective agreement, you keep it out of your collective agreement, right? So accommodation and the return to work process is a pain in the butt if it's in your collective agreement. If it's not, then you can do exactly what you're suggesting. Because as Brett said, it's an accommodation.
So what happens, let's say I'm working for you and I say, hey, I can't come in, for the next week. I have a family emergency. How much information do I have to divulge to you as the employer, or can I just say that?
Well, technically, because there is a leave for that, a protected leave in Ontario, for example, you can have 3 days where the employer can't touch you. But even with that protected leave, and even though it's only 3 days, you're entitled to proof if you require it. So you can technically ask, what's the family emergency? And then you can ask for proof of it if you want, if proof could be had. I like to think that most employers will work with their employees to a certain extent, but certainly if that family emergency extended past 3 days a week, what have you, or if it happened frequently, yeah, there's a duty to inquire on your part.
Okay. Is there a limit of days or weeks that an employer can approve or not approve a leave due to medical reasons?
Nope.
Okay, there we go. See, we're back to the one-word answers. That's what we like. Okay, what do you do if you have an employee who's not working out and you were planning on terminating, but then a family emergency took place and the employee has to go on leave?
You would have to be able to show. Now, a family emergency is a little bit different because a family emergency isn't necessarily covered by the ESA. It is for 3 days in Ontario and other provinces as well, or the jurisdictions begging your pardon. And under the Human Rights Code, unless it falls under family status, and a family emergency might not fall under family status, so you would want more information, but you might not need, you might not have any fear of, you just could terminate. If that same question was asked and it was a medical leave, where there is coverage under the Human Rights Code, then you would have to be able to show that there was reasons for termination that justified the termination. One, two, that there was also a reason why you didn't terminate the person before they went on sick leave. You could have reasons for termination before someone goes on sick leave. And then that last thing, that whatever it was that straw that should have broke the camel's back when you should have terminated, it went another month. Then the person went on sick leave. That begs the question, what happened in that month? Were they acceptable again? Which means that the medical leave is in fact really what has spurred on the reason for the termination. It's a line you draw, like literally. I've done this for clients. It's a super helpful self-exercise. Draw a line where the sick leave starts, and go right before that line and write down everything you can in fragments about why you want to terminate that employee. If there was a gap between the sick leave and the reason why you would terminate the employee, you're taking on a great risk for terminating that employee in a medical leave.
Okay. So if someone is on a gradual return to work, and let's just say they make $40 an hour normally, or like in a day, is it prorated? Not in a day. I'm just trying to make a simple example, and I just totally ruined that. But if it's a gradual return from say 20 hours to 30 hours to 40 hours, is the salary prorated to reflect that, or should it be?
Yeah, legally that's up to you. So like technically you work, you get paid, you don't work, you don't get paid. So, like there's certain times when you're doing gradual return to work, so there's certain times when you'll be able to pay the employee and they'll still be able to collect EI. And there's at a certain point where they really won't be eligible for any portion of EI, but they'll be getting paid more. But no, you technically do not have to pay the employee at 100% unless it's a workplace injury.
Okay, so here's a two-part or a clarification. You accommodate an employee by reducing their hours to part-time. However, company policy states only full-time employees are eligible for benefits. How do you eliminate their benefits without constructively dismissing the employee? And then it was just a correction. My previous question was referring to a permanent accommodation. So it was regarding a permanent accommodation.
A permanent accommodation, like the previous question about the, if it's.
Yeah, so like I'll read it again. So so it's a permanent accommodation where you've reduced the hours to part-time. However, company policy states that only full-time employees are able to get benefits. How or can you eliminate their benefits because you have that policy and you've accommodated them by working part-time?
Honestly, there would be more questions I have to ask about that. So, I'm sure like when that person is reached out to, if you want to do a complimentary advisory call, we can get into it. Happy to help that way, unless you're already a client. You, on the surface, just with the information I have, that's inherently discriminatory. Someone can't lose their benefits because of a disability. So, at that point, you have to put a caveat in your policy that states, but because the reason it's not crystal clear, because if it was not a permanent accommodation, that's a no-brainer. But because it's a permanent accommodation, it's not. You have the right to change the terms of the job in a permanent accommodation. So I'd have to know more about what led the accommodation to be permanent and the details around that, which would require a further conversation. Does that make sense?
Yeah, that makes sense. Yeah, no, I mean, it's like some things aren't going to be complicated to answer, and
sometimes
we'll have
anybody
more
who knows me,
context.
sometimes I talk out loud in my head. So I'll be thinking through a scenario and I'll be talking out loud while I'm answering the question. So yeah, it's kind of funny to look at.
So like before I ask this question, I guess my question is, everyone's can be fired if proper severance is provided.
Provided you don't violate their human rights or ESA.
Okay, so can an employer terminate an employee if proper severance is paid? So let's say they, they're on long-term, as one example, or they're not. And you're like, I just want to get rid of this person. Can you just pay them out in some capacity?
Yeah, the amount of money you'd have to pay them out to avoid that person wanting, like basically what it is you're trying to get a release. So you're paying them out a specific amount of money to get a release so they can't take action against you in a court. Or what we're really talking about here is human rights. If you try to pay somebody out and they're not interested in being paid out, right, then it's a human rights claim. So again, you could terminate somebody for whatever reason in most jurisdictions in Canada, as long as you pay them the appropriate amount of money, which is termination, termination pay in lieu of notice, severance in a couple of jurisdictions, and then in all jurisdictions, common law except Quebec. So, and common law can be quite gaudy, right, which drive a package up to a few years. But at the end of the day, even with that, if it violates their human rights, it's going to take that release for them to sign off on the fact that they're not going to go down that road.
I own a small company and everyone on the sales team is commission. They're all contractors and they're on commission. One of my reps told me he was taking 3 months off to ride his bike across Canada. He thought he would be guaranteed his job upon return. I told him no, as I need to fill your spot ASAP. Although now he might have a spot for him, he may not. It's not guaranteed. Is that appropriate? Is that an appropriate thing to say?
Yeah, it's not a protected leave, right? So when you it's good for employees. I couldn't tell by the question whether he's already done the bike ride and is coming back, or if he's asking in advance before he asks for the leave. If he's asking in advance, then you're right to tell him that I'll try and save your job for you, but if I don't have it to give it back, it's not here, and you're fine. You're completely within your right. If you didn't tell him that before he went on the employer approved leave, or told him that it would be here, but operational reasons dictated that they're no longer there, then yes, you still have the right not to bring him back, but that might lead to a termination rather than a termination and all the obligations that come with that, rather than a resignation, which cost you nothing if you were front up about it, if that makes sense. But if
Here's a question. Okay.
Yeah, if it's not a protected leave, the protections aren't afforded.
Okay, so RE, undue hardship for duty to accommodate. Are you able to explain further on what the following means? Quote, obligation to investigate external funding, end quote. I've never seen it fully explained.
Okay, so basically, and I apologize to everyone on the call because I would do this for hours, but I have a client at 3:30 who's waiting for me.
Oh yeah, I know. We've gone way over.
No, I'll answer this one though. So basically what that means is like there's organizations, whether it be government organizations or whether it be non-for-profit organizations, and probably some other periphery ones as well, who will provide funding in certain circumstances. So a good example, and I'm going to use a physical disability because this is easy. Everyone understands that. Let's say you have somebody who was in an awful car accident, is in a wheelchair, they want to access, their workplace. However, they can't access their workplace because there's 3 steps up to the front. So you need to put in a ramp. The ramp's going to cost $100,000. Right. And this small business doesn't have that. There are places out there that will give you you make applications to the government, you make applications to these non-for-profit agencies who are their sole purpose and mission, which is amazing, is to help companies out or people out in these types of situations. You have an obligation before you can claim undue hardship on the basis of cost of first looking through and provide proof if called on that you went and checked out the external sources of funding that's available to you, whether it be through the government, whether it be through non-for-profits or some sort of periphery agency like that. There's quite a few, to be honest with you. You'd be surprised how many times, if you needed to find external funding to assist somebody with a disability or to make your workplace more accessible, that it's available to employers.
Well, Darcy, thanks so much for that. We still have 79 people tuned in here, 35 minutes over the runtime, but that was great. Lots of information. Looking forward to doing this again.
Yeah, man, it was great. I appreciate you facilitating. It's always great working with you. And Sony, thanks for everything you do behind the scenes. It's terrific. And thank you everyone for participating in the webinar. I hope you found it of value.
All right. Take care. Thanks a lot.